What's up, guys? Today is Friday, January 7th, and we are back on this channel, Wealth on Replay, with my good friend here, Marty Elberg. Say what's up, everybody, Marty.
Hello, everybody. What's up?
And as you guys know, today we're going to be talking about probate. How are you doing? How are you doing today, Marty?
Doing great.
Happy New Year.
Thanks for having me.
No problem, man. So as you guys know, if you don't know, if you haven't seen the previous video, today we're going to be talking to Marty. He's a probate attorney. He actually helped people out in my family and others as well. This guy's very close to me. I just want to say thank you for everything you've done, Marty. As you can see here, he's going to be our teacher for today. As you can see the graphic here.
That cracks me up every time I see it.
So I see a few people tuning in. At the end, guys, if you guys have any questions, please let us know. We'll definitely have Marty answer any of the questions at the end. Let's go ahead and jump right in. So, guys, I know probate is usually a touchy subject with a lot of people. So, Marty, if you can just go ahead and explain what probate is.
Yeah, absolutely. So probate is the court process of transferring assets from somebody that died to those that they leave behind. And they're either going to be heirs, and this is getting pretty technical, but it's what a lot of people want to know, because it's like, how do they know who it's going to? Well, the state has a plan for you, and they've selected who your assets go to if you don't select who they go to.
Wow.
And that means they're default, so that means they're heirs selected by the state. On the other hand, you could have beneficiaries. That's if you make a plan. So before you die, you make a plan. And you say, I want my assets to go to A, B, and C. And then they're called beneficiaries.
Okay.
And that court process of probate transfers assets from the person that made a plan or didn't make a plan to the people that they named as beneficiaries or the state names as heirs.
Okay. Would that be on your will, I'm assuming?
Yep. If you create a will, there are other ways to create a plan, but we're talking about probate. So
right.
A will would create the need for probate. A lot of people think, hey, I have a will. I don't have to go through that court process. I don't have to go through that probate. But that's not accurate. The will is an instruction guide for the judge and the attorney and everybody else on how to get the assets to who you name the assets to go to. Okay. So it still causes us to have to go to probate. Now, there are ways around probate, and we'll get into that later. But since we're defining what probate is, that's what it is. It's a court process. It's frustrating. Right. It's expensive. It can take anywhere from a couple months to a couple years, depending on the complexity.
Wow.
And if anybody's fighting, or if there are claims, or if it just depends on what's going on.
Wow. Okay. Yeah, guys, again, we have Marty Elberg here. He's the bucket list coach. A real good friend of mine. So he's going to teach you guys about probate. I'm going to be asking a lot of different questions today. So again, Marty, just to get a little personal, how long have you been doing probate cases?
Oh boy, about 15 years now.
Okay.
Actually, about 14. It took about a year to get my first probate case. So. Yeah. Because when I was in Iowa, I did general practice, so I did pretty much everything. So it took for a probate case to come in the door. So
14 years, perfect. I know you reside in Florida. Do you do other states or just Florida?
Just Florida now. Yeah, okay. I left my Iowa license. I put it on hold. I didn't want to do the double continuing legal ed, and I wasn't doing a whole lot of business in Iowa. So now it's just Florida.
Just Florida, okay.
Has been for the last, just Florida for the last few years, but I've been in Florida for almost 9 years now. Okay.
And when things like that happen, when it comes to probate, again, it is a very touchy subject. Some people do want to handle, the cases and things like that on their own. So I do get a lot of questions. What are the pros and cons of hiring a probate attorney? Like, when would you think you need a probate attorney? In what situations? I would say all, but who want your legal advice?
From what I've seen, almost always. Because I've gone in and cleaned up probate cases where they haven't hired an attorney.
Wow.
And sometimes it's a little more difficult to even clean it up than it would have been to just start it from the beginning. It is such, let me put it in perspective for the listeners. It's such a weird area with weird rules and terminology that other attorneys don't even want to touch it.
Wow.
If you're not in the estate planning probate world, other attorneys are just like, I don't understand how that works. I'm not going to do it.
And I'm sure for an average person as well, if some people don't get an attorney, all that verbiage as well is going to be very confusing to them too, you know? So
right.
I'm sure, yeah.
And they can they can fill in the forms wrong. They probably don't know who the heirs are. Remember, the heirs are what the state planned for us. They don't know the procedures on what to do with a will, what to do with a death certificate. They can go to the clerk's office. They'll spend an hour, 2 hours there. The clerk will help them fill out the paperwork. They can't give them legal guidance, but they can say, okay, fill out the names that you think are relevant, and we'll submit it and see what happens. And sometimes it's right, but usually it's not.
Right. That's why you come to clean it up at.
Exactly.
And are there different types of probate? Is there just one type of probate, or?
Great question. So yeah, there are two main types that I deal with here in Florida. And one is called a summary administration. That's a quicker process. That's when I said, maybe two months to 2 years. A summary is if there are less than $75,000 of probatable assets, okay, non-exempt assets. So like bank accounts, 401ks that don't have a proper beneficiary designated. And that happens a lot. Make sure you have your beneficiaries designated on your bank accounts, on your 401ks and everything if you don't have a full plan.
Gotcha.
Full plans are different, but you at least have beneficiaries designated. That's the cause of most of the probates that I do, besides having real estate. Okay, having real estate is my number one cause of probates.
Gotcha.
Because they haven't properly titled the property, or it's just they never made a plan, and there are unintended consequences that come with real estate. There are a lot of people that have been living in a house for 10, 15 years, and it was owned by grandma who died 20 years ago. And then dad died 5 years ago. And they're still living there, but mom had 4 kids, and 2 of them are dead, and there are like 5 grandkids. So now it's a complete mess. When grandma probably intended on leaving it to dad, dad intended on leaving it to you or whoever's living in the house, but didn't create a will.
Okay.
Even just a will would have at least got the property to where it was intended. Still have to go through probate, still have to go through the process. But that's, sorry, I kind of got off the topic of the different types of probate. So those are what cause probate. All right. So under 75,000 is summary administration. Now, I said exempt assets are not included in that. An exempt asset would be that house that I was talking about. So let me get back full circle. That was grandma's house where she lived. That's called a homestead. Okay. We've got a couple different meanings or uses of the word homestead. The house where you live, your main residence for 6 months and a day. So it's got to be over 6 months out of the year. That's your homestead. Okay. And then grandma passed it to dad. Dad probably lived there. Okay. So dad's homestead. And then you live there. It's your homestead. So it's exempt. We do not count that in the amount of assets. So that's how we can do that with the summary administration.
Okay. And I know a lot of cases, I know I sent you a few people just personally that, their parent passed away or someone passed away. And this is an off-topic question. I didn't ask you this earlier, but just for me, is there like a timeline if someone passes away that they need to get a probate attorney? Is there like a deadline? Because sometimes I'm hearing someone's living in a home for 3-4 years, and then they're realizing they need a probate attorney. Is there like a specific deadline or no?
Right. So my example I gave you, they're real examples. Grandma died 20 years ago. Dad died
20 years
ago. I've been living in the house. Now I want to sell it. Now what do I do?
Right.
Those are real examples. Those are at least a couple times a year I get a case that's that spread out where now we've got to track down second cousins and cousins because grandma had kids and her kids died. It's an absolute mess.
I can see.
But it can be done. I can put the mess together as long as everybody's on the same page. And if everybody's not on the same page, then we have other ways to handle that. So there is technically, yes, you're supposed to file a death certificate within a certain amount of time. You're supposed to do this, and this, but there's not really a penalty for not doing it in time.
Okay.
In fact, using summary administration, if nothing's been done for 2 years, we can do everything in a summary administration.
Okay.
So just as long as we know the assets and we know what they are, and let's just use a house, for example. So we've got 2 houses. We've got the homestead, and then grandma had a rental property somewhere. Right? That's worth more than $75,000. She's been gone for more than 2 years. I can do a summary administration.
Okay.
If she was gone less than 2 years, then there's the different type of probate. We'll wrap it back around there.
Yep.
And that's a full administration. And that's where we have to name a personal representative. Some people call it executor, but in Florida, we call it personal representative. We have them appointed. We have to publish notice in the local newspaper that we're having probate. We have to have a creditor claim period. We have to have a whole lot more goes on, and that takes quite a bit longer than a summary would.
Yeah, I definitely wouldn't do that on my own. Trust me, I'll be calling you. And when you get that initial phone call, how long does it normally take from beginning to end? Usually, on a probate case.
Yep. So it depends on the complexity. It depends on what types of assets there are. First of all, it depends on what type of case I can file. If I can do a summary administration, usually and it depends on which county as well.
Okay.
So I can work in every county in the state. I've probably filed probates in 20 different counties, and they all work differently. So just because I know how to do one in one county doesn't mean I know how to do them in all. It means I know how to do the procedure or the actual documents, but the procedure for each county is different. So Miami-Dade's different than Broward. Broward's different than Palm Beach. Palm Beach is different than Hillsborough. So once I figure out the little nuances, it makes it a lot easier. So once I do one, I can figure out the procedure and it's like, oh, okay, I got it. I remember. Or if I don't remember, I just go to my database of this county. Oh yeah, that's what I have to do.
Okay.
So it depends. It depends on, and that's the best. That's the best attorney answer everybody always gets, right? It depends. But if it's a summary administration, if it's Broward County, it could be 2 to 3 weeks, as long as you're responsive and you get documents back to me, information back to me, everything done on a timely basis. So if it's quick, 2 to 3 weeks. Most people lag a little bit in getting documents back, because they've got to get them signed and usually in front of a notary. So got to take a little bit of time off, go to a notary, get them signed, get them back to me. I file them with the court, and I file everything electronically. So there's no need to go to the courthouse anymore.
Okay.
Don't have to have in-person hearings in most cases anymore.
Wow.
So as bad as COVID was, it's really bounced us into modern technology. Before I had to go to the courthouse to get an order signed. Now I submit it and it's signed. And as attorneys, we have these resources available to us that the general public doesn't have. So it definitely helps out. So to get your answer, 3 weeks on the shortest end, and that's with a summary administration. Can't do that with a full administration. To a year and a half, 2 years, and that just depends on what's going on with all the assets and any other issues that may come up. We've got a tax issue on one of the cases that's been open for probably about a year and a half. Finally got word from the IRS that they got it cleared up. So,
wow, a year and a half.
We should be able to close that one out in the next couple months.
Okay.
Just because of all and that was a IRS issue. We had to do it the last tax return, and then they found an error and they overpaid, or the IRS thought they should pay and they thought they overpaid. So it was a mess, and their CPA got involved and got it all straightened out.
A year and a half later.
Yeah, saved the state a couple $1,000s, but also took an extra 6 months to deal with the IRS, 8 months to deal with the IRS. So it depends on what's going on. But most cases, I'm going to say a month to 6 months.
A month to 6 months. Okay.
Yeah, a month to 6 months. If there's no glitch. There's no glitch in the systems, a month to 6 months.
Okay. Doesn't sound like it takes so long. And I do see new viewers coming in. Again, guys, we're talking to Marty Elberg. He's a probate attorney. He's going to be answering some real good questions about if an unlikely event is somebody would have passed away. These things do happen. I know it's uncomfortable sometimes, but you definitely want to make sure that you have the right person helping you with that. And right before we get into our story time, Marty, we do have a question. The question says, so even though there's a will, it still has to go through probate. So they want to know if the person that passed had a will, does it still have to go to probate?
Yep. And I touched on that a little earlier, but yes, absolutely. If the will is a set of instructions for the court and everybody else to know where your assets are going. Okay. If you don't have a will, it's up to the state where your assets go. If you have a will, it says, hey, I want my stuff to go to this person, this person, this person. I don't want this person to have anything. That's what the court looks at, and the court says, okay, these people get your stuff.
Gotcha.
In as simple terms as possible. It's your stuff from the dead person to the people that you want them to go to.
Exactly. Now, the question is another off-topic question. What if somebody passes away, and what if someone doesn't know anything what to do? Like, they don't know what to do at all. Like, is there someone that reaches out to them and says, hey, they have a will? Is there a specific person that's appointed? Like, just hypothetically, someone passes and they don't know anything. They don't know if that person had a will or anything. Is there someone appointed to call out and reach to them, or do they have to do their own research, like an attorney, to find that stuff?
Yep. No, they have to do their own research to find that stuff. Every once in a while, there'll be attorneys that keep wills, that keep the estate plans, that keep them in their vault.
Okay.
And they, I don't know, they might do some research. I don't do that. Most of the attorneys I know do not keep wills anymore. It used to be common practice.
Okay.
And the reason behind it was, hey, I've got your will, I'll do your probate. And now they're moving away from that. I don't keep wills. I'm paperless, basically.
Okay.
So I create the estate plan for people, and I send them the hard copies, and I keep digital. So I have digital copies of pretty much everything.
Okay, makes sense.
But there's not really a mechanism that says, hey, there was a will here. Unless let me go back to another unless. There are a couple different scenarios. The attorney keeps it and watches the obituaries, I guess. I don't know how they I don't know how they would be alerted, but
exactly.
There's probably a way out there that says, hey, I got these people on my registry, so if they die, let me know.
Right.
I don't do that, so I don't know. The other way is a will could be recorded with the courthouse. So if you create a will, you can take it to the courthouse and they'll record it, and they'll keep the original. And so the court will document that there's a will on file. Now the problem with that is if you update your will and you don't take it to the courthouse and nobody knows about the updates, the will is going to supersede it. Well, just it's the only one there.
Right.
Nobody knew about the update. So if you do that, make sure you also record the updated will.
That makes sense. Okay.
Yeah.
I learned something new.
I've got a situation like that now, where the attorney kept the original and filed it. About a week later, I went to file the probate case, and the clerk said, "Hey, there's already a case open." The attorney filed the will. I'm like, "Oh, okay, great." Well, mom thinks a new will was written and is kept in the safe deposit box. So now we have to go in that case that the attorney with the will filed. He didn't open a probate, he just filed the will.
Right.
And we have to open up the safe deposit box, which is a whole nother process.
Right.
So that's a whole nother tangent that I would go on with clients that have safe deposit boxes.
Okay.
Most of the time, I would say, don't get a safe deposit box unless you have somebody else that has authorized access to that box.
Okay.
So,
and I'm going to go deep in your memory bank here. You got to give us a story time. Like, give us a nice, where a situation where someone thought they didn't need a probate lawyer, and it could have been worse before you stepped in. Just to give some people some context on why this is definitely needed, especially nowadays. Want to hear something from you, like specifically what happened, what occurred, and how you helped out.
All right, so I'll give you kind of a hybrid case where an older gentleman had an estate plan, had a trust, so we could avoid probate. So he could avoid probate when he passed his things on to his kids. Okay. Had a will, he had everything properly put in place, except there was an account that he didn't have go to the trust. So when we have a trust, I know we haven't really talked about trust, but a trust is a document. I like to have people picture it as a box. We put our stuff in the box, and that box avoids probate. So we don't have to go through this process, the court process. Well, they had that set up. But there was one asset hanging around out here. It was a bank account that wasn't directed to go to the trust. It didn't have any beneficiaries designated. I don't know what happened with that situation. I didn't prepare the documents for this person, or help them set it up to make sure it was properly funded. But they had everything else going to the trust, and the trust was divided, no problem at all. So no court intervention. The person called me and said, "What do I do?" I said, "You let them all know. You let all the beneficiaries that are named know that you are the person that's taken over this, and that you will be dispersing the money as soon as you gather everything." And that's all that I was needed for.
Okay.
And then about 6 months later, he contacts me and says, "Oh, I found an account that there wasn't a designation. So what do we do?" I'm like, "Well, we have to go to probate for that." So we had to go to probate for that one account.
For that one account wasn't in the trust.
Yeah, because it wasn't in the trust. So we had to go to probate, and it was over $75,000. So it was a substantial account, but it was the process, and it could have been avoided had they properly designated beneficiaries, or the trust as the beneficiary.
Okay. Yeah, I could avoid the whole situation, I see.
Yeah, and it was I don't want to say difficult probate, but the person that was in charge is one of the brothers, and didn't have a great relationship with a couple of the siblings. I think there were like 4 or 5 siblings. Didn't have a great relationships with a couple of the siblings, so they were always questioning what he was doing and why he was doing this and why it was taking so long. And so it really puts a lot of pressure on the people that you leave behind if you don't have a proper plan, even if you do have a proper plan, because this guy did, and he had the will, and the will directed that it goes to the trust, which is what we call a pour over will, but we still had to go through the process to get it to the trust so that he could disperse it after that. So it can be very frustrating. That's why I say it's a very frustrating, very costly process. It doesn't matter how long it takes. It's not something somebody that's left behind wants to deal with.
Right.
Mourn the loss of a loved one, not talk to an attorney and wait for the court to give them what they should already have.
And with those siblings and family members, usually when someone passes away, I normally see that family members and siblings start fighting for their property. How do you prevent claims against the estate? What if they, set up a claim first? What happens in that situation?
All right, so there just happened to be a situation where some sisters of a person who died went to probate, went and filed the probate on their own. And they thought they should be entitled to the property, but this person left 2 young kids behind. Was divorced and had 2 kids. So we had to go in and we had to file a motion to strike their petition. Okay, petition is asking the court to disperse property the way you ask for it. All right. One thing they did properly was what we call an affidavit of heirs. They did that properly. They listed the kids on the document. So I'm sure the judge saw that and said, well, I'm not going to give the property to these sisters because he's got kids.
Right.
So I think they just kind of pretty much abandoned it by that time. By the time I filed the motion to dismiss, because they didn't respond to it. And we got it resolved. But had they not properly filled that affidavit of heirs out and left the kids off, the judge may well have signed an order to go to the sisters. Yeah.
Wow.
So luckily there was some. I don't know that, and I don't know the family. I don't know them.
Right.
So I don't know if it was malicious or if they just didn't know.
Right.
They probably thought, "Hey, we're the sisters. We should get this property. He's got kids. They're divorced. Because they didn't read the statute. Because nobody does. Which goes back to your first question you asked: should you hire an attorney?
Right.
It's just a whole different language. Even if you read the statute, you might not understand it. Right. I still have to go back to it every once in a while when I look at certain situations and I think, okay. It's got a kid, it's got another kid, it's got married, and I put it together, and it's a puzzle. It really is. It's a puzzle. I put together the family tree, and I figure out the pieces of the puzzle, what pieces are missing, what pieces are still there, which pieces are relevant, which are not. So you have to catch it in time. And had we not caught it in time, had they left the kids off, and the judge issued an order, we could have gone back in and rescinded the order, asked for the judge to rescind the order, to cancel the order, and then start over. So we could have done that. But
that's actually going to be my next question. Then, unlikely event you lose a probate case, what are your options? So it sounds like you can do a dispute process, get it rescinded, and get it changed like that. So that's kind of good to hear in case
it's got to be done within a certain amount of time, though. You don't have forever. You've got to, and I got to tell you, I haven't looked up the statute of limitations. That's the time limit.
Right.
That this happened to when you want to make your claim. There is a time limit. I haven't needed to deal with that, so I can't tell you off the top of my head. I can find out. But,
just do it ASAP.
Just
do it as soon as possible.
As soon as you find out, do it. If you have a loved one that died,
get it done.
Yeah, if you're married, if you're a kid, if you are the mother of kids, make sure you do it right away. It's just it can get ugly. I've got another case that's not going to be. It's going to get ugly, and by ugly I mean litigation. And I don't do the litigation side of it. I've got another attorney that comes in and does that. But I've told her I'm going to open the probate, and then the relatives are going to start filing claims, and they're going to start fighting about who should be what, and it's going to be a mess. So we'll get it open. We'll bring this other attorney in, and he'll handle the litigation part of it. So yeah. And then there are creditor claims too. So we didn't really talk about creditor claims.
Wow, I didn't think about that.
Yeah, if the creditor claims are valid, we can pay them. Sometimes we can even negotiate them down. So it's like, hey, there's only $10,000 in this estate, and your claim is for 5. Will you take 2? So we can do negotiations. We can object to the claim. Okay, I don't find that as ethical or unethical. It's just something I like to talk to the clients about.
Okay.
Some attorneys just automatically object to them. I don't think that's proper. Again, I'm not going to say ethical or unethical. I just don't think it's proper procedure, because if the creditor decides, no, I'm going after this, then they have to file another lawsuit, and then it just escalates from there. And then you could be responsible for their attorney's fees as well as your attorney's fees to fight that. So it's got to be a conversation about, should we pay this or just object? And if it's not about, and I've objected on claims that people are like, no way, that is not valid.
Okay.
We've objected on those, and they just go away. So if they don't file a response within a certain amount of time, then it just goes away.
Okay. And I know you did touch on, if you have a 401k, we need beneficiaries, things like that, just to make sure everything goes smoothly. What advice would you give someone watching this video, or anyone in general, to make sure the process goes smoothly in the future? What steps would you say to do now to prevent any headaches in the future?
I would say try to avoid probate. I do estate planning, and that's I probably would do about 2/3 estate planning and 1/3 probate. And it is expensive to do a proper estate plan. Okay, you can go online, you can get a will, you can go online, you can get a trust. I don't know what the trust is going to have in it, if it's going to have what you need.
Okay.
It might be enough, it might not be enough. I don't know. I know I'm an estate planning attorney, and I have attorneys coming to me to do their estate plan. That's how complicated it can be. I make it as simple as possible for people, but as whatever the cost is, it far exceeds the cost and the frustration of probate. So having a proper plan in place, I keep saying proper, because some people have a plan. Like one of the questions was, oh, I have a will, I shouldn't have to go to probate.
Right.
No, that's a plan. I don't think it's a proper plan. We want to avoid probate. It costs a little bit to make sure you can, and we're avoiding probate. Let me take you back to that example with the kids. Okay.
Right.
So now the kids own this house. Now what do you do with it? Well, now the mom has to go to the court, get a guardianship over the assets, not a guardianship over the kids. She already is the mom.
Right.
But to be able to control those assets or help with the assets for the kids, she has to go to court, get appointed a guardian, and deal with the court system until they either sell the property and the money is gone, and they've got to go back every year and report to the court. Okay, I spent this much money on the kids doing this. I spent this much money on the kids doing this. So there's no. It's tough, and it's gonna be a struggle for a while. All right, I don't handle that part of it. I don't handle that, and that's also considered part of probate. Guardianships are inside of probate. I don't do that. So to avoid that, if Dad would have created a trust, okay, that house could have been held inside that trust. Remember, in the box, we could have put that house in the box, and then we could have appointed somebody to manage this house for his 2 minor kids, minor under 18, okay? And that person wouldn't have to go to court. Would just say, okay, hey, I'm going to rent this house out, and I'm going to give I'm sure we've got an account set up for each of you girls and or each of you kids, and every month you're going to get $500 each month, because that's the whatever the net proceeds of the rent would be.
Right.
Or we're going to sell this, and we're going to open an investment account, and all the proceeds are going to go into this account, and we're going to take care of your expenses, health, education, maintenance, support, until a certain amount, until a certain age. And then when you get to that certain age, here you go. We're going to turn it over to you, and it's yours. No court involvement, and they have access immediately as opposed to waiting for this whole court process.
Okay.
So if they want to sell the house, they've got to go to court. They've got to go get a guardianship. They've got to have the sale approved by the court.
Wow.
They've got to have it go into a certain account that the court has oversight on. They've got to follow all of these procedures that could have just been avoided like that.
Right, with the trust.
By taking a little bit of time, spending a little bit of money, and getting a proper plan put in place for the kids.
Right. Okay. Well, that's a lot of good information. And I appreciate you, Marty, today. If guys don't know, Marty is the bucket list coach. All his information will be in the description box. His Facebook and IG handle will be there. His email address as well. If you guys have any questions, this is a guy I know personally. Helps me a lot. And again, I appreciate you taking your time out today to help me, with this live and as well. Any other thoughts for the viewers for today?
Just take a look at what you have. And there are some people that I understand they can't afford a few $1,000s for a proper plan. So number one, make sure beneficiaries are designated on every account you have. Every bank account, every savings account, checking account, stock brokerage account, IRA, 401k, that IRA that you had from the job 5 years ago that you forgot all about. Make sure they're taken care of. Your life insurance, whether it's your private one or the one at work, make sure you've got a beneficiary designated. Okay? Free to do. You don't have to talk to an attorney. You just call your financial institution or your employer and say, hey, I had to add a beneficiary, make sure I have one added.
Right.
And you might say, well, it's called pay on death or transfer on death. That's fine. I don't want to confuse you with all that. But if that's what they say, okay, great. Beneficiary, pay on death, transfer on death, basically the same thing. But beneficiary is easy for you all to remember. To call your financial institutions or look it up online and fill out a beneficiary designation form, get it done. That is the absolute least you can do.
Minimum.
Okay? Then there's more than that. And I say that with hesitation because I don't want you to assign a minor. Somebody that's 18 as a beneficiary, because then we have that same guardianship issue that we just talked about with the house. So there are better ways to do it. But if that's the only thing you can afford to do, which is nothing, if you've got money, you should be able to afford to do something. But if it's in a 401k or a life insurance policy, I get it. At least designate a beneficiary.
Gotcha. Do you do payment plans? Because we'll talk about that earlier.
I do payment plans to a certain extent. And it's not spread out over a year. But I'm open to the discussion. I certainly could do a payment plan. Usually it's half up front and half when we sign the documents, which is really only about a 3 to 5 week period. It depends on how fast clients get back to me. Because I can turn around documents within a week, but then they review them, and sometimes it takes a little bit longer to make sure that's what they want without any changes. And they might have changes. So anywhere from a week to 4 weeks is my normal cycle. Usually about 2 to 3 weeks.
Okay. Well, not bad. Well, again, thank you again, Marty. This was I learned a lot today. I'm not going to lie to you. And I'm sure we'll do this again. I appreciate you coming on today to my channel, Wealth on Replay, where we teach different wealth tips and strategies. Just want to say, appreciate you, Marty. Have a great Friday.
Thank you.
And everyone that's watching this video, man, I hope you guys got some good information. All his information will be in the description box. Contact him directly. He's the attorney, not me. So make sure you reach out to him with any of those questions. And you have a wonderful day, Marty, okay?
All right, you too. Have a great weekend. Bye.
You too, man. Thank you.